Good morning. I hereby call to order this 18th meeting of the Pennsylvania Public Utility Commission for the year 2016. Since this is our last public meeting before Veterans Day, I would like to invite Rob Bigeman from our staff, who's a U.S. Navy veteran, to lead us now in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much, Rob, and thank you also for your service to our country. The first matter on this morning's agenda is the minutes of the meeting of October 6, 2016, and I will call on Commissioner Paulson, who is the editor of the minutes.
Thank you, Madam Chair. I have reviewed the minutes from the October meeting and ask that they be approved as submitted here this morning.
We have a motion by Commissioner Paulson for the approval of the minutes. Is there a second?
Second.
Second by Commissioner Sweet. Any discussion, any edits? I love to say any edits. I'm waiting for someone to say I have an edit now.
I'll get on that then.
Okay. Hearing none. All those in favor say aye.
Aye. Aye.
Any opposed? The motion passes 5-0. And now we will call up our Director of the Office of Special Assistance, Cheryl Walker Davis, to lead us through today's agenda.
Thank you, Madam Chairman and Commissioners. Good morning.
Good morning.
Morning.
May it please this honorable commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Office of Special Assistance. It is, with regard to the first item, they're appearing pertaining to the two formal complaints of Core Communications, Inc. versus Verizon Pennsylvania, LLC, and Verizon North, LLC. We have your motion, Madam Chairman, as well as the statement of Commissioner Sweet.
Do we have a motion to call up this matter for consideration?
So moved.
Do we have a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Paulson, and I would turn it over to Vice Chairman Place to preside at this time.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
Thank you. I would ask that my motion be submitted on the record in its entirety, and I will summarize it for you. This motion resolves an intercarrier compensation dispute between Verizon Pennsylvania and Verizon North and the Core Communications for entrance facilities. Core disputes Verizon's charges to Core for entrance facilities at any rate other than the total element long-run incremental cost, which is TELRIC rates. Verizon counterclaims that Core owes special access rates for these facilities. Because of the ambiguity in the ICA's provision of entrance facilities under Section 251C2 or 251C3, in accordance with the United States Supreme Court decision in Talk America, I believe Core should be billed at TELRIC rates for Verizon PA entrance facilities. Consequently, Verizon must issue an invoice using TELRIC rates for Core's use of Verizon PA LITG entrance facilities for past service subject to the 4-year statute of limitations as provided in the draft order and going forward to the day of entry of an opinion order in this matter. Verizon shall provide that invoice to Core within 60 days of entry of an opinion and order. Therefore, I move that, along with the other invoice recalculations to be undertaken in the order, Verizon shall submit a revised invoice to Core reflecting a TELRIC rate for the Verizon PA LITG entrance facilities previously billed at tariff rates for the period August 16, 2007 through the date of the entry of this opinion and order using the rates specified in Appendix A, which is Exhibit A as well. 2, Verizon shall submit all revised Verizon invoice calculations to Core as required by this opinion and order during the period August 16, 2007 through the date of the entry of this opinion and order, within 60 days of entry of this opinion and order. 3, Core shall pay the revised Verizon invoices within 90 days of receipt from Verizon. 4, Core shall return to Verizon a bill credit 35% of all payments received from Verizon for third-party originated traffic from August 16, 2007, as set forth in the opinion and order. And finally, OSA shall prepare an opinion and order consistent with this motion.
Thank you. Is there a second to the motion?
Second.
Seconded by Commissioner Coleman. Any discussion?
Vice Chairman?
Please.
Let me just, I want to take this opportunity to thank Chairman Brown for this motion here this morning. As we all know, this is a very complex intercarrier compensation case, and I'd be remiss here this morning in not thanking our staff members, in particular Joe Whitmer, Matt Titino, Labros Pilos, Regina Matz, and Matt Titino for the cooperative manner in really kind of fleshing through some of the complexities of this case. So, Chairman Brown, your motion obviously articulates the final outcome, but again, I'd be remiss here this morning in not recognizing the staffs that worked on this very complex intercarrier compensation case, which, by the way, has been around for quite a while here at the Commission. So today's actions, before we take the vote, I just, again, would be remiss in not commenting on the work done by our staffs on this particular issue. Thank you.
Thank you. Any further discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? The motion carries 5-0. Chairman, the gavel is yours.
On the matter as amended by the motion, is there any further discussion? Commissioner Sweet.
A familiar refrain, Madam Chair. Before joining my staff as legal counsel, Susan Colwell was working in the Office of Administrative Law Judge and worked on this case in her capacity as an ALJ. Please note she has not advised me on this matter.
Thank you very much. Any further discussion? Hearing none. All those in favor of the case amended by the motion, please say aye.
Aye. Aye. Aye.
Any opposed?
And concurring in result only.
The motion passes 5-0, noting Vice Chairman Place is concurring in result only.
Turning to the next matter, it is recommended that the Commission adopt the staff recommendation to release for comment a settlement achieved in a matter involving an investigation by the Commission's Bureau of Investigation and Enforcement against Columbia Gas of PA for certain incidents occurring during infrastructure replacement projects, noting the statement of Vice Chairman Place.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Powelson, second by Vice Chairman Place. Under discussion, I would recognize Vice Chairman Place for his statement.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I had read it in its entirety. Before the Commission for consideration and disposition is the joint petition for approval of settlement agreement filed on May 5th, 2016 by the Commission's Bureau of Investigation and Enforcement and Columbia Gas of Pennsylvania Incorporated. This settlement resolves two separate events. The first involved the installation of a plastic main to replace an existing steel main. While locating and repairing an identified leak in the newly installed main, a contractor cut into the pressurized section of the pipe, causing the end cap to fail, striking a contractor's employee in the lower leg, resulting in a severe injury. In the second event, an unqualified contractor's employee sustained injuries to his foot and ankle while performing a pigging operation. The settlement parties are to be commended for working cooperatively to identify corrective procedures, and I fully support the implementation of the safety improvements articulated in this settlement. However, both events resulted from failures of procedure, training, and oversight, causing avoidable severe injuries. Although the settlement parties fully support the fines proposed, I would be interested in any comments that address the issues in the settlement, including the fines imposed. Thank you.
Thank you, Vice Chairman Place. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? Motion passes 5-0.
Turning now to page 2 of the public meeting agenda and continuing with the presentation of matters on behalf of the Office of Special Assistance, it is recommended that the Commission adopt the staff recommendations appearing with regard to the first two items pertaining to the Commission's Bureau of Investigation and Enforcement versus Alpha Omega Limousine Network, as well as the recommendation in the matter involving the petition for interlocutory review of Ross E. Shell versus PPL Electric Utilities Corporation.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to the next matter involving the Bureau of Investigation and Enforcement investigation of the Fairview Energy, Inc., and potential unlicensed brokering of electric generation service. We have the motion of Commissioner Sweet.
Is there a motion to call up this matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Vice Chairman Place. Under discussion, I would call on Commissioner Sweet for his motion.
Thank you. I ask that my motion be placed upon the record as if I had read it in its entirety. Before the Commission is a staff recommendation to approve a joint petition for settlement between the Commission's Bureau of Investigation and Enforcement, I&E, and Fairview Energy, Inc., of all issues raised in the complaint filed by I&E. In short, the settlement resolves all issues raised by the complaint regarding Fairview Energy's practice as a broker without first obtaining proper licensing from this Commission. In addition to the substantive terms of the settlement, the parties added a paragraph which asks the Commission to remove a document from the record of the case upon approval of the settlement. I do not believe it is appropriate to alter the documentary record in an on-the-record case before the Commission, and particularly here where the document is authored by someone not a party to the settlement. Therefore, consistent with that regulation and the requirement that the documentary record contain all filings made during the case, I move. Number one, that the Commission approve the settlement with the exception of paragraph 40D. Secondly, that the Office of Special Assistance prepare and order an opinion consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Coleman. Under discussion, I would recognize Commissioner Powson.
Thank you, Madam Chair. Just for the record here this morning, I support this settlement as negotiated by the parties here this morning without modification. Thank you.
Thank you. Any further discussion? So on the motion, all those in favor say aye.
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 Any opposed?
I will be voting no, Madam Chair.
The motion passes 4-0. On the matter as amended by the motion, any further discussion? Commissioner Powson.
Madam Chair, I will be voting no. Let me correct my first vote. I will be voting yes to the staff recommendation. On the question in front of us, I will be voting no. Sorry. I was a little ahead of myself. So.
Okay.
It's Thursday.
So on the matter as amended by the motion, you will be voting no.
Correct.
Okay. Any further discussion? On the matter as amended, all those in favor say aye.
Aye.
Any opposed?
I'm a
No. Motion passes 4-1 as amended.
Continuing with the presentation of agenda items and turning now to matters on behalf of the Bureau of Technical Utility Services, in omnibus fashion, it is recommended that the Commission adopt the staff recommendations, commencing with that appearing at the top of page 3 in the proceeding involving the UGI Utilities, Inc. Gas Division's petition for approval of its distribution system improvement charge, continuing with the remaining recommendations on pages 3, 4, and 5 through and including the recommendation in the proceeding involving the UGI Penn Natural Gas Company Supplement Number 62 to Tariff PNG Gas PAPUC Number 8 pertaining to creating a combined account and bill for customers receiving both UGI PNG and UGI Utilities Inc. Electric Division service.
Is there a motion to adopt the staff recommendations?
so moved.
I heard a so moved by both Commissioner Powson and Commissioner Coleman, so I will take one as the moving and one as the second, if they don't mind.
We'll thummy war it. I'll go second.
Okay. Since you're becoming neighbor president, I was going to give you the moving party, make you the moving party.
But Coleman has more stature than I do, so I'm going to recognize him.
I'm laughing too much. Commissioner Coleman moves, Commissioner Powson seconds. Any discussion? After all that, I don't think we need any further discussion. Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters on page 6 of the public meeting agenda and matters presented on behalf of the Law Bureau, again in omnibus fashion, it is recommended that the Commission adopt the various recommendations there appearing, commencing with that in the proceeding involving the PA Universal Service Fund size recommendations, and concluding with the recommendation in the matter involving the ratification of the emergency order issued with regard to Respond Power LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Powson. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Office of Administrative Law Judge with regard to the first matter appearing at the top of page 7, that involving the complaint of John J. Rounce versus Pico Energy Company. We have the motion of Commissioner Sweet as well as the statement of Vice Chairman Place.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. On discussion, I would recognize Commissioner Sweet for his motion.
Thank you, Madam Chair. I ask that the entire motion be placed upon the record as if I had read it in its entirety. Before the Commission is an initial decision dismissing the formal complaint of John J. Rounce. The complainant filed a formal complaint with the Commission against Pico Energy Company, alleging to have experienced reliability, safety, and quality problems with his electrical service. Specifically, from January 1, 2011 through January 1, 2016, Pico recorded 18 sustained outages lasting longer than 5 minutes in duration. While Pico was able to identify the cause for the complainant's outages and has implemented a series of improvement procedures intended to ensure future reliable service, the fact remains the customer did not receive reasonably continuous service as required by the Public Utility Code. The record shows that Pico has taken this complaint seriously and has engaged in numerous efforts to upgrade the service on the subject line. But I am concerned that these efforts have fallen short of achieving the level of service expected by Pico's customers and required by the code. In addition to experiencing a high number of power outages, the complainant alleges to have experienced surges, voltage spikes, voltage drops, brownouts, and service outages. He also reported safety concerns after finding an underground, insulated, high-voltage cable that remained exposed for 81 days. Therefore, I move that the portion of the complaint raising outage issues be sustained and be referred to the Commission's Bureau of Technical Utility Services, TUS, for further review. I also move that the matter be referred to the Bureau of Investigation and Enforcement to take whatever further action may be warranted with respect to the alleged inadequate services issues which have been raised by the complaint.
You have heard the motion by,
Well, never
oh, I'm sorry.
That's the now.
I'm sorry.
Now, therefore, so what?
Sorry about that.
Therefore, I move that the initial decision is reversed. The complaint filed by John J. Rounce against Pico Energy Company at C-2015-2506941 is sustained in part. 3, that this case be referred to TUS to further review and monitor the reliability and the service provided to the complainant's home. 4, that the opinion and order issued in this matter be served on the Bureau of Investigation and Enforcement to take whatever further action may be warranted. 5, that the Office of Special Assistants prepare an opinion and order consistent with this motion. Thank you.
Thank you. You've heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Powson. Under discussion, I would recognize Vice Chairman Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I had read it in its entirety. Before the Commission for consideration and disposition is the initial decision in the complaint proceeding of John J. Rounce against Pico Energy Company at the above referenced docket. Mr. Rounce alleged that he has experienced problems with his electric service, including numerous outages, surges, spikes, and brownouts as a Pico customer over an extended period of time. As relief, Mr. Rounce requested that the Commission conduct independent testing and investigate the alleged service issues to his residence. ALJ Vero conducted a hearing on February 1st, 2016, in which exhibits and testimony were entered into the record by the complainant and the company. The record in this proceeding clearly demonstrates that there were 18 sustained outages at Mr. Rounce's residence over a 5-year period. As Commissioner Sweet noted, January 2011 through January 2016. The record shows that these outages had many causes: tree growth, a line cut by a contractor, an ice storm, a lightning strike twice, a fallen tree limb, an underground cable fault twice, and a car colliding with a utility pole twice. The record did not, I would note, the record did not state whether it was the same car twice. Both the complainants and the company entered evidence into the record demonstrating the outages and related causes. The record also demonstrates that PECO addressed these outages as well as the reliability of the company's Middleton 352 distribution circuit, which serves Mr. Rounce's home. Mr. Rounce alleged surges and spikes. PECO installed a recording voltmeter at Mr. Rounce's residence following Mr. Rounce's complaint of dirty power. Following 10 days of continuous measurement, the results indicated that the voltage had remained within the limits permitted by Commission regulation. This is the only evidence in the record concerning this particular issue. In addition, Mr. Rounce alleged that he witnessed PECO laying a high-voltage power cable above ground, creating an unsafe condition in his neighborhood. The complainant believed that the high-voltage cable and other PECO underground equipment remained exposed for 81 days following a service outage in August 2015, creating unsafe conditions. PECO's witness indicated that it installed a temporary cable to restore power, and the 2400-volt line was fully insulated and covered by cable rays to protect it from oncoming traffic. PECO also indicated that Mr. Rounce's service was not affected by the power outage on August 2015 or by the cable replacement that followed. The laying of protected temporary cable is a permissible practice for the duration of an emergency. However, no facts were presented to dispute the emergency nature for the cable in this case. I believe that the record in the proceeding demonstrates that the company employed significant remediation efforts, including testing and reliability measures to address Mr. Rounce's concerns and to restore electrical service to Mr. Rounce's home, as well as any other affected properties. I believe that the record was fully developed by both the complainant and the company, and the evidence clearly demonstrates that PECO corrected the various outages through appropriate and safe measures over the time period involved. Mr. Rounce has failed to meet his burden of proving that he is entitled to the relief that he is seeking from the Commission. Therefore, I support the findings of the initial decision that the formal complaint filed by Mr. Rounce against PECO Energy Company at this docket should be denied. Thank you.
Thank you, Vice Chairman Place. On the motion, any further discussion? Hearing none. All those in favor say aye.
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 Any opposed?
Opposed.
The motion passes 4-1, noting the dissent of Vice Chairman Place. On the matter as amended by the motion, is there any further discussion? Without objection, we can take the previous roll call. Hearing none, the motion passes 4-1, noting the dissent of Vice Chairman Place.
Continuing with the presentation of matters on behalf of the Commission's Office of Administrative Law Judge, it is recommended that the Commission adopt both ALJ Vero's recommended decision in the proceeding involving the general rate increase of the Community Utilities of Pennsylvania, Inc., Water Division, as well as the recommendation of ALJ Watson in the matter involving the Peoples Natural Gas Company, LLC, and Peoples Natural Gas Company, LLC Equitable Division, proposal to replace its service expansion program.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion?
Madam Chair,
Commissioner Powelson.
thank you. Regarding the People Natural Gas Company case involving their, I'll call it their Get Gas tariff expansion, I'm a little bit troubled in looking at this case, as we had one utility, UGI, that has been very successful in implementing their gas expansion tariff to customers. This company is basically coming to us today to say we are not getting the penetration rate for our Get Gas tariff, so we want to embed it into a new surcharge on the bill. My concern here is one utility, and actually other utilities, were extremely successful in marketing this program to customers. As I challenge my staff on this particular case, I'm just troubled by the potential lack of marketing that was not properly conducted in bringing this get gas tariff to customers. So I'm obviously supporting the case, but I'm troubled by looking at this in terms of looking at other utilities that have been extremely successful in bringing gas expansion tariff opportunities to customers, and this utility not having that success. So I just want to note that here for the record this morning, but again, I will be supporting the supplemental filing here this morning.
Thank you, Commissioner Powelson. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to page 8 of the public meeting agenda, it is recommended that the commission adopt ALJ Jones's recommended decision in the matter involving the UGI Utilities, Inc. Electric Division's default service plan, noting your statement, Madam Chairman.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
A motion by Vice Chairman Place, second by Commissioner Coleman is who I heard first. And under discussion, I have a statement to be read into the record. I would ask that my entire statement be submitted for the record, and I will summarize the statement for you. Before the Commission for consideration and disposition is the petition of UGI for approval of its default service plan. There is one matter of concern that I must raise, namely the apparent lack of any new or grandfathered long-term contracts within UGI's proposed default service portfolio. Testimony in the original petition references a long-standing arrangement whereby UGI receives energy from the New York Power Authority. However, this direct testimony in the joint petition for settlement appears to be devoid of any facts detailing contract length characteristics for this New York Power Authority arrangement. Therefore, I am unable to determine if this default service plan satisfies the prudent mix standard under 2807C(E) of the Public Utility Code. Relevant case law does permit the Commission to deviate from the prudent mix mandate in Section 2807 of the Code, so long as it expressly deliberates the possibility of including a mix of contracts and determines that it is not prudent to do so. In the Popowski case, Popowski versus the PUC, the Commonwealth Court ruled that this commission acted within its bounds of Act 129 when the commission approved a 100% spot market procurement. However, the court also found that the commission's approval of a spot market only procurement in light of the prudent mix standard was lawful since the commission properly considered the possibility of including other contracts. The instant proceeding lacks any explicit evidence detailing contracts in excess of 4 years and lacks any express justification for the apparent omission of long-term contracts. Therefore, I must respectfully vote no. I would further like to state that it is incumbent upon parties in default service proceedings to clearly detail all contracts included in energy portfolios. This is necessary so that this commission can adequately determine a utility's compliance within Section 2807E of the Pennsylvania Public Utility Code and relevant case law. Any further discussion?
Madam Chair, if I might.
Commissioner Sweet.
Thank you. First, I want to commend you for continuing to highlight this issue and has certainly sensitized me to it as well. And I join your comments and will vote accordingly on those comments. I realize sometimes in this world it takes a while to turn a big ship in the middle of a river and turn it around a little bit. I think we need to steadily do that on this issue. I think the chair has sent a message a couple of times on this particular issue to further accentuate her point, perhaps to emphasize it. I join with you and will vote no on the motion as well.
Thank you, Commissioner Sweet. Any further discussion?
Madam Chair,
Commissioner Powelson.
let me just, for the record here this morning, kind of put this in a perspective of the prudent mixed language and how it was developed. Prudent mixed language was designed as a result of two convergent points in electric competition. One was the rate cap expirations hitting in the later part of the 2010-2011 timeframe, coupled with a situation in the wholesale power markets where we had $14 per MMBTU gas. If we fast forward from 2008 to 2016, we'd realize that wholesale power prices have dropped precipitously. In fact, it's somewhere up around 60% over the last 8 years. And we know part of that scenario is being driven in large part to the Marcellus shale development. One of the things that I think would be critically important for our Office of Technical Utility Services, or perhaps our Office of Competitive Market Oversight, to look at is putting some analytics behind what spot market purchases would look like in the window of 2008 to 2016. The point being here is the analytics would show that spot market prices were far in the public interest for consumers out in the market here this morning. I recognize the statute. I recognize why it was designed. It was a reaction to two events. Those events, we've transitioned to market. We celebrate a 20-year milestone here soon, and customers are shopping. Check that box. In the markets now, we're learning that wholesale power prices have dropped to such a level where customers are shielded from any potential $14 per MMBTU gas market spikes. So I just share that. I recognize the statement made by Commissioner Sweet, and I also give deference to the chairman because she probably had a hard, long nights working on the prudent mixed language. And again, Act 129, as originally designed, was a great piece of legislation in bringing customers new energy efficiency measures. But behind that, let's keep in mind, in July of 2008, we had $14 per MMBTU gas, and we had a horrific run-up in wholesale power prices. So just want to state that here this morning. Thank you, Madam Chair.
Commissioner Powelson, I do thank you for your comments. And in response, I have to say, yes, I do remember very well the reason behind the drafting of the procurement language, since I was one of the staff drafters at that time. And I also duly note and have considered in all my statements throughout this time the jurisdiction of the Commonwealth Court. And I'm not trying to vote no. What I'm trying to do is follow what the court said in their court opinion that said that the PUC looked at all these relevant things. As the economic regulator, I would think it's incumbent upon us to continue to look at all of these relevant factors because we have the concern of the consumer. And I only ask that any utility that's providing a default service plan to us at that time provide the information to us. It is fine that our staff would look at these different measures, but I think it's incumbent upon the utility that's submitting a plan to also provide those factors as well so that we can take everything into consideration. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? I will be voting no.
I'm also no, excuse me.
The motion passes 3-2.
That does conclude the presentation of regular agenda items. Turning now to the carrying agenda. It is recommended on behalf of the Bureau of Technical Utility Services that the Commission adopt its two recommendations appearing with regard to the matter identified as Aqua Pennsylvania Wastewater, Inc., pertaining to the acquisition by Aqua of the wastewater system assets of the Linton Area Municipal Authority, as well as the recommendation for the issuance of a license to Fairview Energy, Inc.
Is there a motion to adopt the staff recommendations?
So moved.
I heard Commissioner Powelson and Commissioner Coleman, so we'll take one as the mover and Commissioner Coleman as the second. Is there any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And on behalf of the Law Bureau, at the bottom of the carrying agenda, it is recommended that the Commission adopt the recommendation there appearing with regard to the matter identified as the FCC Lifeline Broadband Order, Carrier, and Consumer Awareness, and the eligibility criteria for Lifeline participants.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that does conclude the presentation of agenda items.
Thank you very much. Before we adjourn, would like to acknowledge that November is Critical Infrastructure Month and would like to make some comments. We know that this month is very important and would like to make sure that we recognize it. We know that the utility systems are the backbone of our daily activities. Electricity powers our homes and businesses. Natural gas provides fuel for heating and cooking. We depend upon clean drinking water. Transportation systems get us where we need to be. And telecommunications and internet services connect us with work, family, and friends. Keeping these critical systems secure and operating in the face of everything from natural disasters to man-made threats is a key part of our responsibility to our citizens and our communities and our national security. And we need to work equally hard to improve the resilience of these systems so that the services can be restored more quickly when problems arise. The PUC is committed to working with key stakeholders, including our local, state, and federal agencies, our utilities, of course, our military and law enforcement agencies, our emergency response organizations, our neighboring states, and our nonprofit organizations. Earlier this year, as you know, we collaborated with the governor's office to host a Black Sky exercise right here in this room, testing the state's response to a large-scale outage event. The exercise drew about 130 participants, and it was an eye-opening experience for everyone that was involved, highlighting how much work we have already done to safeguard our systems and also noting how far we still need to go. As noted during our exercise, we absolutely hope that this does not happen, but we need to be prepared to help life as we know it continue if it does happen. And this is a priority for myself as well as my fellow commissioners, and I know the entire Public Utility Commission. So I also know that Commissioner Powelson and I are very much interested in these issues as we both serve on the Critical Infrastructure Committee at NARUC, and so I do want to give him the opportunity to say a few remarks as well.
Well, thank you, Madam Chair, and I certainly want to associate myself with your remarks and appreciate the leadership that you've shown on these issues. I think you alluded to the Black Sky exercise, which really, again, sheds light on the fact of what we take for granted every day as utility customers and things that can happen out there. The Critical Infrastructure Security and Resilience Month really serves as a reminder to all public utility commissions across the country of our roles in working cooperatively with our utilities on things like, as the chairman mentioned, grid resiliency, storm restoration, mutual assistance. And I want to also commend Commissioner Coleman. I remember we had a couple weather events one time, Commissioner Coleman, back in October one year, and we had to have an en banc hearing. And one of the outcomes via his leadership was looking at underperforming circuits in the grid. And I think if you look at Pennsylvania today and under Chairman Brown's leadership, I think Pennsylvania is a national role model when it comes to where we are with addressing grid resiliency and storm restoration efforts. Now, I probably have jinxed us in saying that, but it is a recognition here this month that regardless of the type of emergencies we face, it's important that, again, we work collectively together to safeguard our infrastructure and position the Commonwealth of Pennsylvania for swift recovery to keep our communities safe. And I think, again, a lot of that work goes out or recognized by people like Dan Searforce here at the Commission as well. And with that, Madam Chair, again, I thank you for your leadership in adopting this resolution here this morning.
Thank you, Commissioner Powelson. I am the type of person, I do not like to take credit for anything that I cannot take credit for. And so I also want to recognize you, Commissioner Powelson, for your leadership, because I know that through the years, even before I came on the commission, dealing with a lot of weather-related events, what the PUC has put forth and worked with the utilities to do that. When we had our big 30 inches of snow this past winter, I said directly to the governor, I am the beneficiary of all the hard work under the leadership of Commissioner Powelson that has gone into different efforts in terms of resiliency for our critical infrastructure. So I do want to thank you also for your efforts.
Thank you, Madam Chair. And I thank Commissioner Coleman, too, because he persevered as well through those years.
It's a love fest up here. And to continue the love fest, we also want to make sure we recognize our staff people. We do, as an agency, a state agency, work with the Leadership Development Institute. And this year, we did have a staff person that participated in it, but unfortunately, he was unable to go to his graduation and receive his diploma. So at this point, we do want to take time to recognize Nathan Paul, who was a graduate of this program, which is designed to develop Commonwealth managers who demonstrate leadership potential and the ability to succeed in positions of greater responsibility. The program includes monthly training sessions that run from March through October. The formal sessions focus on contemporary leadership issues to address theories and practices which all guide employees as they transition from managers to leaders. The LDI experience includes opportunities to gain knowledge of current leadership theories, concepts, models, and techniques. This is achieved through the use of presentations, discussions, self-assessment, instruments, executive interviews, book discussions, case studies, networking, and workshops. Participation in this program requires a significant time, commitment, and dedication by the participants, and we just want to congratulate Nathan, who was a member of this 23rd graduating class. I want to present to him his certificate that he was not able to receive on graduation day. It has a letter from Governor Wolf to Nathan, as well as the certificate, which says this is to certify that Nathan Paul has successfully completed the class of 2016 Leadership Development Institute, and signed by Secretary Minnick on November 4th, 2016. So Nathan, if you can come forward, we can present this to you.
Well done.
Thank you. And nothing coming before us for the meeting. I would entertain a motion to adjourn.
So moved.
So moved.
Second.
Second. All in favor, say aye.
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 I know this is unusual, but I just did a motion. So meeting is adjourned.